Let's talk about doing bad things with people and planning it in advance. That's the case we're going to talk about right now.
Perfect intro.
It was.
All right. We got a case that's really good. Came out of the BC Court of Appeal. It's R.V. Hoffman, 2024, BCCA 98. Just released recently.
Very fresh.
And, well, by the time this goes up, it'll be like a week old or something like that. But this is about a case where some people hook up and they talk about doing bad things together on sexting, right? So there's all over text. And so they have one hookup, and then the incident that this individual is charged with is the second hookup, right? Which ended in a way...
Take it slow so everybody understands. The facts are really important here with the decision.
But so, and this is important because, as we've said before, the BDSM community, and there was a little bit of kinky stuff going on, not like craziness or whatever, but
ass slaps.
But ass slaps, some slapping, the face, and some spitting water and stuff like that. A little bit of stuff that was negotiated though, over text
in advance, in writing,
and after their first hookup, and so the BDSM community thinks that you can get things in text. And then that means that you're allowed to do whatever. But the reality is, no, you can't get advance consent.
Correct.
And so this is a really interesting case about this individual who was charged in these
we can say the name. It's a public decision. R.V. Hoffman.
Hoffman was charged. The complainant's name is publication ban. But so he's charged in this.
Nope, it's published.
He's
the
just
full name.
He's just dying to say it.
The name of the complainant.
No, but the accused.
The accused, yeah, I know. I'm saying it's Hoffman. But,
2024 BCCA 98.
Yeah. And so, and it's interesting because in this, they were talking about text messages that were not permitted. This is an appeal case.
Mm-hmm. This is so important. Take this slow. Yeah. This is really fucking important.
So this guy's been convicted.
This is like a CPD part of our podcast without me completely being psycho.
So he's convicted, and this is his appeal of his conviction. Right. And so they're reviewing things that took place during the trial. He had brought a pretrial application called a 276, which is other sexual history, and a 278 application, 278.92 to be precise, to use
very precise
text messages in his possession, which so any material, documents in the accused possession, you have to bring a pretrial application. And so he was denied that application. Then they went to trial, and then he brought a mid-trial application to reopen it, which you can do, because certain things happened. And so, one of the things going into this, because I've been talking a little bit, I want to hand it over to you guys to weigh in a little bit before I carry on about what else is going on here.
Carry on.
But so, we have a case coming up in which they decided to delay the decision in the pretrial application until we were into trial. So talk about the difference about that. Pretrial application versus a mid-trial application.
Okay, so we bring applications ahead of time with respect to any records in our possession or other sexual evidence. That's brought like a lot in advance. So we file everything 3, 4, 5 months in advance. The hearing is at least 2 months in advance of the trial. And the idea is to negotiate and get a ruling on what evidence is admissible so that we're all on the level playing field as to what is appropriate evidence at trial.
Explain to people what records are.
Records can
that was a big dispute
any
for
messages,
a while.
So text messages, messages over apps, photographs, videos, cards, anything.
Do they have to be related to the offense, alleged offense?
No.
Exactly.
Anything in your possession you want to use as part of your defense has to be vetted through a judge because there are privacy interests in the complainant. Bill C-51, which is something I've always talked about for the last 4 years on this podcast, drives us nuts. Thank you, Mr. Trudeau. But leaving that aside, so you can bring this application ahead of time, or in a particular case we have right now, which is an anomaly for us,
it is.
Stage 2. So this is where you deal with the evidence. It passed stage 1. It's relevant.
Potentially.
All deferred to the trial. So we have to hear the evidence of the complainant and then argue, after we hear the evidence of the complainant, what may or may not be relevant. I can't argue with the logic of that because that's something we thought about a long time ago. It was the way to deal with it. And a judge in the provincial court system had thought that was the appropriate process, and he's an extremely bright judge, extremely bright lawyer when he was a defense lawyer.
Mid-trial, yeah.
Yeah, makes sense.
But
Because then the complainant would testify before they know, because complainants have access to your application.
Stage 2.
So you want them to testify first, ideally, so they don't know what evidence you plan on bringing until after they've already testified in chief, right?
But I've come to the view, so have you, that we need to filter evidence, because there's a lot of stuff which is just f***ing irrelevant, bullshit, bad character, inappropriate evidence that should never make it to the daylight of court. And we need to focus a little bit on what the Crown evidence is in cross-examination. And imagine you're at trial, and I don't do it off the cuff. We prepare our cross-examinations. And I suggest to any lawyer watching this, you prepare your cross-examinations ahead of time in detail. So at the end of their evidence, you got to argue this and then retool your cross. Not so easy.
But what you were saying earlier, that's kind of an important point. We don't just put in the evidence that we intend on using. We identify stuff that the Crown potentially
100%.
may lead, which the Crown has not brought an application for, bad character evidence or,
Right.
Other things, which they should, or other sexual activity the complainant mentioned in their statement. And we don't want it to be led, but the Crown may lead it.
So we are often in our applications or adjoining applications raising issues about evidence that the Crown will call as to other sexual evidence or bad character and objecting to it. We're doing that all ahead of time. And frankly, we see
we
that
must.
we have to.
We don't have a choice.
But we see the value in streamlining this so that we are all on the same playing field. Right. So we're facing in this one particular case where now we'll hear the evidence of the complainant and figure it out then.
Yeah, because
I have a little bit of concern about it.
We don't really know, and this is the reality: is that you don't really know for sure what the complainant's going to say when they testify. So they're saying, well,
even
let's
though
wait
you have
and
their
see,
statement, you don't know.
So this case really kind of lays this out well in
great.
terms of how this works. And so one of the things that happened at trial is the Crown, the prosecutor from the States, the prosecutor tried to sanitize the evidence that was brought out at trial by asking the complainant, well, were you friendly or were you unfriendly? Right? So they put this binary kind of thing. I hate using that word, binary.
Careful.
So friendly or unfriendly, but they didn't want to get into the fact that it was sexualized, right? And so she said, oh, no, it was friendly. But she said, I just wanted to get to know him better, right? Meanwhile, there's all these messages that were not permitted to be used at trial that show that they were actually negotiating specific sexual acts, right? And the Crown knows this in their cross-examination, that all this evidence is blocked. And so, and then the complainant, they started the cross-examination before they reopened the application. And in the cross-examination, they just started out saying, did you have any plans in advance to have sex with him? And she says, no, I did not. So then, of course, they have grounds to reopen the application. Because before, you could say, oh, well, just the fact that she said, I want to do these particular sexual acts does not mean that you have permission to do those acts on her because she said it in advance. But now she's denied it at trial that she had any plans with him whatsoever for sexual acts. Now it's grounded and there's a legitimate reason.
What happened on a mid-trial application?
So they reopened it, but like you mentioned, stage 2, there's a stage 1. So when they reopened, the judge says, well, this is a new application. It should start at stage 1. And then he was still stuck on this whole idea that it was advanced consent. So he denied stage 1, said there's no possibility. And that was deemed to be wrong.
Slow that down, though.
Yeah.
On stage 1,
he
is excluded.
Is it possible to have relevance? Is there any possibility it might have relevance? And stage 2 is where you argue whether or not the relevance is more prejudicial or more probative.
So there were numerous text messages they exchanged between the previous encounter on the date. Some of these messages were highly sexualized.
Your favorite one?
Mr. X contends primarily that as a result of the judge's error, he was unable to effectively challenge the complainant's credibility. The Crown was able to unfairly undermine credibility, and the jury was left with a mistaken impression of the events and issue. This is f***ing significant. Okay? The appeal was allowed.
Slow it down. But you read that really fast.
Yes.
So this is really important. And this is a great decision to really hit home what we've been saying forever. Okay. The argument of the of the accused, okay, on trial we call him the appellant, he was unable to effectively challenge the complainant's credibility. The Crown was able to unfairly undermine his credibility.
Right.
Because without these messages in, it was an unfair basis to challenge the complainant's evidence. And the jury was left with a mistaken impression of the events in issue. The appeal was allowed. The judge largely discharged his duties, blah, blah, blah. But given the central role of credibility in the trial, the excluded evidence had significant probative value that was not substantially outweighed by its prejudicial effect. The excluded evidence was essential to ensuring that the accused had a fair trial. The risk of twin meth reasoning and of offending the complainant's dignity and privacy could have adequately been addressed by limiting scope of cross-examination and through appropriate instructions.
So there's two things that come up in there.
He had an unfair trial because this judge f***ed it up.
But, okay, so there's two things that
Because
came up in
credibility
what
is
you
the
read.
central issue.
It up as a legal
Set
term.
up
Yeah.
as a legal term.
Bad.
So particularly in this case, the Crown used the absence of evidence to support his guilt, to say, oh, well, he says such and such, but there's no evidence of
no
that.
evidence of that.
Think,
But the
just say
Crown-
that slowly. Because this is knowing what the messages were.
Yeah.
Right.
So the Crown knew that there were messages that could have supported the accused
Right.
evidence and successfully blocked those messages from trial and then submitted
the
to the
absence
jury that there was an
against, yeah.
absence of evidence that should be held against him.
That's
right?
pretty greasy.
So this was actually a point that they said, even though they decided that that he should have a retrial for different reasons, they still addressed this fairly egregious behavior. And the Crown also crossed him about how he went there with the intent of having sex that night, but also blocked whether or not her intentions were to have sex that night, right?
Kind of missing part of the
This
equation.
is and so one of the particular messages, which is like
Okay,
one of the
you've
messages
been
was
dying
like,
to say this.
he has a message that was blocked in which he said after their first encounter, prior to the allegations, he texts, "I left my handprint on your ass."
Have you seen it lately?
And then she has pictures of bruises, and he's trying to say, well, yeah, but the bruises came from the first encounter, but he wasn't allowed to talk about what happened at the first encounter, and he wasn't allowed to give evidence that he texted her, "I left my handprint on your ass." And that's what she was in for when she invited him over. She wanted more of that. And the jury never got to hear any of that.
Shocking.
Yeah. So this is the thing we talk
Pretty
about. It's like
subdued.
this is why the right to full answer in defense is so important, and this is one of the things I like about this decision.
It's about in for the sake of this bullshit, sometimes myth reasoning, you sanitize a trial and erase the reality of it. Mm-hmm. The whole relationship, the whole context, the whole messaging, you erase all of it, so you got an artificial trial based upon artificial evidence.
Right.
This is a wonderful example of why that's bad.
Yeah. And the decision is a very lengthy one because
There's so many points here. It would take 7 episodes
he had
to go through
15
this.
grounds of appeal, and he lost most of them because they were technical things about
right.
stage 1, stage 2, this, that. Can they review a certain decision by a judge, or does the judge have deference or whatever?
But they got this part, right?
It's like it's not until you get to the end. But in terms of what we were talking about, in terms of the way the Crown led evidence in the main decision, they said, I say only, the Crown must always be careful not to make improper use of the absence of excluded evidence during cross-examination of an accused. For example, in this case, if Mr. Hoffman is permitted to testify...
Yeah, you're going fast.
Sorry.
Slow down.
This is really important.
Yeah, okay. So the Crown must be careful not to make improper use of the absence of excluded evidence during the cross-examination of an accused. And then they give the example in this case, if Mr. Hoffman is permitted to testify at the retrial that he observed bruising on the complainant's buttocks on an earlier date, it would be improper for the Crown to suggest in cross-examination that there is no evidence to corroborate that testimony. In fact, there is corroborative evidence in the form of his excluded "I left my handprint" text message, A cross-examiner may not put suggestions to the witness recklessly or that he or she knows to be false.
Right.
And that is a problem with these applications. When they fight against our evidence and then they try to take the exclusion of that evidence and
Use it against.
But I
can
have to
go-
say,
it can go
the
into that area
prosecutor in
as
this
being
case,
something they know to be false.
you know,
Right.
I think the prosecutor in this case was quite reckless compared to other prosecutors we know. This one really took advantage and went way too far.
Right.
But this is a perfect example of how it can be abused.
I know, and this is why appeals are important, and this is why we need to protect appeals too, where they don't just defer to judges all the time. Where they really need to.
Well, this was hard to defer.
They did a
This
great
was hard
job.
to
They
defer.
did
This
great
was a
job.
palpable
They had
overriding
to,
error.
Yeah, they had to override this.
And they also say the Crown was well aware of the nature and number of text messages that the parties had exchanged over the weeks leading up to the date of the incident, the alleged incident, including those that had been excluded. Further, as the judge pointed out in his mid-trial ruling, it is, quote, unhelpful, unwarranted, and unwise, end quote, to speculate that, quote, only relationships that are stable and well-established and not nascent will involve sexual activity. This is another important thing, too, because and we've seen this before, well, they barely knew each other.
Right.
Therefore, it's unlikely that this person would have consented to such and such sexual activity. So they made a really important point, too, in closing submissions from this particular Crown, that they advised the jury that it's unlikely, they shouldn't believe that a woman would agree to such activity because they didn't have a very lengthy relationship.
You mean the slapping?
Why would she let him leave a handprint on her ass if she'd only met him twice?
Can I just?
That's essentially what they were saying.
Exactly.
I just want to go back. So, for 1 second. So, these applications we've talked about a lot through this podcast that we've done. So, because of Bill C-51, we have to bring these applications to admit any messages or other records in our possession. So, we have to vet it before a judge. And what's important at stage one is to get the test right. What is the threshold for admissibility for these messages? Okay, and it's generally well understood amongst judges what that threshold is, but you know what? Every so often they don't get it right. In this case, the judge misstated the standard of proof for stage one. In his paragraph of reasons, he said it was basically the balance of probability, and that balance of probability is a higher standard than what is the real standard, focus, of what is the test of admissibility in stage one. It's capable of being admissible. That's a lower threshold.
Very low threshold.
Very low.
Right.
To get to the full argument.
That's right.
That's right.
About it. Yeah. There's something really important so there was a concurring decision, which means they agree with the outcome that he should be, the majority said retrial. But this concurring judge wanted to add some more content, and it was endorsed by the Chief Justice who wrote the majority decision. And there's a really important section in here that stood out for me, where she really focused on, and
Sorry,
quote,
this bothers me. The parties' submissions on the pretrial were that the stage one threshold was low, and that judge only had to determine whether the proposed evidence was capable of being admissible. Further, judge blah blah blah. I want to emphasize this. I'm sorry. It's sorry. You can go on.
And I will.
I know.
Yes, you will.
but when you're at stage one, it's capable of admissible. It's a
That's so
fucking low
low.
threshold.
Yeah.
Very low.
Low
They
threshold.
should have a proper hearing for all of these.
It should not be excluded stage one unless it's not capable of being admissible. And that is it's like jumping over a baseboard. Okay, I'm done on this part. Go ahead.
So the concurring judge wrote, the importance of cross-examination in a trial on a sexual assault charge where only two witnesses, the complainant and the accused, testify and then offer diametrically opposed evidence on a key issue, is well recognized. Credibility in such cases becomes central in determining whether the offense is proven beyond a reasonable doubt. And then she says the approach the jury should take, and she describes a standard WD, which everybody knows, that upholds the reasonable doubt. And So this became one of the big things about this
Credibility.
case.
Imagine
is
that.
the fact that credibility is not a myth or stereotype to challenge the credibility of a complainant. It is a
Okay, so
central
this is the central
aspect.
focus of this podcast.
Yeah.
Credibility of a complainant in a sexual assault case is a central feature of a trial. It is not collateral. It is ridiculous how many times we face opposition to the admission of evidence on these pretrial motions where they say credibility is not the issue.
They try to say that it's
insane.
actually a myth or stereotype to challenge
Right.
credibility. We've seen that.
Slow.
Yeah.
Say that again.
Unpack it.
So when we say that
Diana
evidence
say
we
that.
have, it's rebuttal of statements made by the complainant. Therefore, it challenges the credibility. And we've had multiple Crown prosecutors try to tell us that you can't just say I'm challenging the credibility because that's impermissible use.
Impermissible,
use is
yeah.
a myth or stereotype that complainants lie about sexual assault. No. Credibility, especially in a case where you've only got
He says,
usually
she
the he
says.
said, she said thing, the credibility of each of those
That's
witnesses
core.
is going to be the core issue in determining the outcome of the trial.
Imagine.
And so this is a really good case, and they have great case law in it that just reaffirms that. Credibility is an absolute legitimate purpose to bring evidence in to challenge credibility
figure.
of the complainant.
It's no myth.
Oh my God! Go figure. Credibility is a legitimate basis.
Imagine
oh my
that.
God! Somebody's believability is a legitimate basis to admit evidence. Oh my God! Oh my God! I can't believe that. How many times do we have to have this argument? That's why I love this decision the most. It again emphasizes what we know from the Supreme Court of Canada on several occasions and the Ontario Court of Appeal. Credibility is a central issue on a sexual assault case. It's relevant. So evidence that can challenge the credibility on material issues of the complainant is highly relevant. It's extremely important for a number of reasons. One, evidence like this is admissible for specific purposes, in particular credibility. Second, on a stage one, you don't just exclude evidence on some willy-nilly absurd analysis that it has to be reaching something. It's just capable of admissibility. It's a low threshold.
Baseboard.
There was this case is important for that, and there's also, I found, like, if you read the full thing, is really focused
We
on.
literally could have
it's-
several episodes.
Yeah,
on
it's
this.
really focused on in the concurring opinion, but they reinforce the right to full answer in defense, how important that is, and how important cross-examination, fulsome cross-examination is. And you cannot unfairly curtail the right to cross-examine somebody on an issue that has some probative value. It doesn't have to be determinative, right? You don't have to prove that this is like a smoking gun or something like that.
Right.
But if it has some probative value, to unfairly curtail the cross-examination, could warrant a retrial. And judges, need to be cautious of that, because I think it's been a problem where they're so afraid for the last decade, so afraid of being accused of rape myths or things like that, that they're leaning too far on the side of, protecting privacy interests. We have
limiting cross-examination.
and limiting
Unfairly.
proper cross-examination. And we had a good decision, some decisions that are sketchy, but it's been fairly strong that privacy interests mean it just can't be trifling, right? In terms of their invasion on their privacy. It's got to have, probative value. It's got to be more than trifling. And to hit
But again, that's not
to hit
like a
their
major
privacy
threshold.
issues,
No.
it's got to go to the core biographical dignity of a complainant. Just making them uncomfortable,
Not enough, yeah.
it's not enough. And so I think this is a really good decision to reinforce that, and hopefully
And as you said
it will help
correctly,
make a difference.
when evidence is excluded, what the Crown can use fairly in cross-examination and not use,
And trying to say the absence of evidence that they know
yeah, that's
exists, but
bad.
is absent only from the trial because
Right.
they managed to successfully block it. That's outrageous.
And greasy.
total mistrial. So let's circle back for a moment. Let's talk about these applications and evidence, okay? This was a great foundation for this discussion that we've been having, I think, throughout all our, is it 3.5 years? 3 years of doing this. Credibility of a complainant in a sexual assault case is the central issue, period. Mm-hmm. There really is very little that's not relevant to credibility, save and except for these myth-based reasoning, which we've never
we agree.
transgressed. Yeah. But there's a lot that is relevant to credibility. And let's be fair about it. People lie.
Are you kidding me?
But what do we also know?
Do people lie?
Really?
And what do we also know? Sometimes
people
people tell the truth, but they've convinced themselves of something. They're
That's
unreliable.
Right. That's right.
Okay,
credibility
you're right.
and
So there is
reliability.
reliability and credibility. And I
credibility.
agree with you. There are instances where a particular complainant, through other reasons, may come to believe something that's not true because of panic, anxiety,
Borderline
misconception.
personality disorder, which is
Therapy.
another
Not
word.
going to get into that.
This is another way of saying woman.
That may be legitimate, that there may be reasons why somebody is not reliable. Their ability to perceive an event and then recount it because of external factors and internal factors, 100%.
I feel for those people who actually believe something to be true, but they're wrong.
And it happens.
It happens.
If you think of yourself in a traumatic experience, you may question yourself about what you viewed simply because of the impact of the trauma, unlike what others will have you believe. Leaving that aside, when we're talking about credibility as a central issue, there's a lot of evidence that may be directly challenging somebody's credibility that should not be excluded because A, it's collateral, or B, because it goes to a myriad of made-up bullshit myth-based reasoning issues. Okay, and they want to expand that list as much as they can to exclude cross-examination. And that's something we have to be really careful about. And this case brought us back to, again, say credibility is a central factor that is something that must be protected because it goes to the heart of making full answer in defense.
It's like bringing back common sense.
Crook.
Good old
I
Crook.
know. I know.
Good old Crook.
No, I think that was a good decision.
It was. Everybody was so freaked out by it, but it was actually a really great decision.
You have to read it a number of times.
Yeah. So this case, I think, one, is really important for the BDSM community to look at this about advanced consent, because this is a case where they literally negotiated what they were going to do.
Well, they don't get how they don't get how in
Start
jeopardy
paying
they
attention.
are. They don't get how in jeopardy they are.
No, they don't. Their lifestyle is practically illegal, and they need to start paying attention.
Now you're being judgmental.
No, but really.
No.
I'm not judgmental at all. That's the
I'm
problem.
kidding.
I'm not, but the legal system is, right? They
Right.
need to understand this. Just because you have something in writing doesn't mean you're allowed to do it.
Right.
Well, and if
they
it
don't
results
understand
in any type of physical harm,
Can't consent to
consent.
bodily
you got a
harm.
problem with that.
Yes,
Yeah.
you do.
Right? So let's think about a case where you agree to a particular act that results in some physical harm. That's a criminal offense. Your only defense may be accident. But if you have messages about agreeing to this particular act, you have a pretty reasonable basis to presume you're going to undertake an act that will cause harm. It's not a joke. You've got to be careful about this. It's illegal.
But this case, it's a lengthy case. It's also very good for lawyers who watch our podcast, because we know they do, to read it in full, because it really thoroughly goes through what were good grounds of appeal and what weren't good grounds of appeal.
I agree.
So it actually would help people when they're crafting their applications to know what arguments to make and what not to make. Because I really think if you make a bad argument in these applications, it can then prejudice the judge. They'll have that stuck in their head, and then they'll deny you
It's a roller
the same
coaster, I feel,
evidence
yeah.
because
Dominoes.
they have this other thing stuck in their head.
Right.
That's
right?
a good point.
It's a good
So
point.
I think it's really important to frame your applications properly.
It's hard, though.
Get it right the first time, as much as you can. But also, it's a really good case to advise Crown. You can't have your cake and eat it too. You can't deny evidence and then also use the absence of evidence.
Yeah, that's
You
bad.
can't deny the evidence. It's now not admissible. And then cross-examine on the basis that the evidence
What's
isn't there to
good for the
support.
goose is good for the gander. All those phrases.
Right. But
about
these
a
are
forest.
important points because that is
Can't see the trees for the forest.
Where the cake is.
Or
Yes.
where the cake is.
Yeah.
Yeah.
It's all connected.
All right.
Get that pillow.
Okay, I
Diana,
think
get
we're at
that
the end of
pillow.
the
Get the
podcast.
pillow right. Don't forget to like, comment, subscribe, and share.
Are you gonna play a song to kind of end it all, or?
Hold on. I don't want to be sued.
Now I got sunshine.
Well, I think you're at the point where it doesn't matter. So
Hold
You
on.
can play multiple songs.
I think I'm gonna end it now.
What's
What?
I'm gonna end it now.
What's another civil action?
You're ending it now?
Yeah.
Okay, bye.
He just ended it.